Let's take a look at a BFOQ defense. Employers that base employment decisions on protected class characteristics are engaging in disparate treatment. When they do so overtly and argue that it's necessary to limit a particular type of employment to people with specific protected class characteristics, this type of disparate treatment is termed a facially discriminatory policy or practice. It is not necessary to delve into the employer's motive in such cases because policy or practice is discriminatory on its face. An important, albeit limited, defense is available to employers that adopt facially discriminatory requirements. If an employer can show that a protected class characteristic is a bona fide occupational qualification, a BFOQ, for the job in question, the facially discriminatory requirement is legal. Employers must not establish protected class requirements for jobs except in rare instances where those protected class requirements are BFOQs for the job in question. But because racial discrimination was the central problem that motivated passage of the Civil Rights Act, Congress was unwilling to allow for any circumstances in which employment opportunity could be limited on the basis of race or color. Thus, the BFOQ defense is not available for policies that facially discriminate on the basis of race or color, and employers must not establish racial requirements for jobs. Although the term reasonably necessary does not sound overly exacting, the Equal Employment Opportunity Commission and the courts have made it clear that this is a narrow exception to the general rule prohibiting disparate treatment. It is important to distinguish disparate impact cases. In some neutral requirements, like employment tests with discriminatory effects, must be defended as job-related and consistent with business necessity. Alternatively, disparate treatment cases involve facially discriminatory policies in which specifications based on protected classes, like we want to hire female servers because that's what our customers want, must be defended as a BFOQ. These terms apply in different contexts and are not synonymous. A disparate impact claim can be defended if it's challenged as a requirement is associated with the job and job performance and appears reasonable given the nature of the business. In contrast, defense of a facially discriminatory policy requires that the employer show that only people with the specified protected class characteristic can do the job, and that that job is integral to the operation of the business. In other words, hiring people without the specified protected class characteristic would not lead simply to lower job performance, but would ultimately undermine the business. Arguments for BFOQs based on discriminatory preferences of customers, coworkers, or clients are usually unsuccessful. Otherwise, employers could shrink their responsibilities by blaming others. It really would like to hire a woman as a vice president, but our senior managers are old-fashioned and wouldn't be comfortable dealing with her. This would leave a gaping hole in anti-discrimination law.